So, good day everyone. I'm Jubilian Espalyarco and I'm the presenter and I will present the section 1, 2, and 3. So, let's proceed. Section 1, Definition and Documents. Article 1, Definitions. Article 1, 1.01, Act of God or Force Majeure shall mean any event beyond the reasonable control of the owner of the contractor and which is unavoidable, notwithstanding the reasonable care of the party affected, and shall include without limitation the following: war, hostilities, or warlike operations, whether a state of war be declared or not, invasion, act of foreign enemy, civil war, and rebellion, revolution, insurrection, mutiny, usurpation of civil or military government, conspiracy, riot, civil commotion, terrorist act, confiscation, nationalization, mobilization, commandeering, or requisite by under the order of any government or de jure or de facto authority or ruler, or any act of failure to act of any local, state, or national government authority. Strike, sabotage, lockout, embargo, import restriction, port congestion, lack of usual means of public transportation and communication, industrial dispute, shipwreck, shortage or restriction of power supply, epidemic, quarantine plague, earthquakes, landslide, volcanic activity, fire, flood, inundation, tidal wave, typhoon, or cyclone, hurricane, storm, lightning, or other inclement weather condition, nuclear and pressure waves, or other natural or physical disaster. Shortage of labor, material, or utilities were caused by circumstances that are themselves force majeure. 1.02 Advertisement or invitation to bid refers to the notice published by the owner or the invitation issued to prospective bidders, giving information as to the nature of the proposed project, conditions for issuance of contract documents, date of bidding, and information that would give the contractor a general idea of, of the magnitude and extent of the project. 1.3 Agreement. Agreement is the term used to describe the agreement signed by the owner and the contractor, excluding the contract documents which are attached thereto. 1.04 Bid. So bid is the tender or proposal or quotation or offer of a bidder to perform the work described in the contract which in form and substance complies with the instruction to bidder. 1.05 Bid bond. Bid bond refers to any acceptable form of bond accompanying the bid submitted by the bidder as a guarantee that the bidder will enter the contract with the owner for the construction of the work if the contract is awarded to him. So it's important. And 1.06 Bid documents. Bid documents collectively refers to all documents provided or made available to prospective bidders, which include the invitation to bid and a copy of the contract, which the winning bidders would be required to sign with the owner. 1.07 Bid Bulletin is a document containing additional information on bid documents issued to bidders before date of bidding. 1.08 Breakdown of work and corresponding value is a listing of the different part of the work indicating each part and its corresponding value. And 1.09, change order. Change order is a written order to the contractor used by the owner after the execution of the contract, authorizing a change or variation in the work or an adjustment in the contract price or contract time. 1.10, contract. Contract is the term used to describe the agreement and the contract documents. 1.11, contract documents. Contract documents are the documents attached to the agreement identified therein as contract. Contract documents, including all additions, deletions, modifications incorporated therein. These generally include the following documents. So, the contract documents, including special provision or condition, general addition, specification, drawings, other bid documents. 1.12, contract price. Contract price is the amount in money or other consideration to be paid by the owner to the contractor for the execution of the work in accordance with the contract. 1.13, contractor. So the contractor is the person or firm duly registered and licensed by the Philippine Contractors Accreditation Board whose proposal has been accepted and to whom was awarded the contract to execute the work. 1.14, cost. Cost means all expenditures properly incurred or to be incurred, whether on or off the site, including overhead and other changes properly allocable thereto, but not include any allowance for profit. 1.15, drawings. Drawings are graphical presentation of the work. They include all supplementary details and shop drawings. And 1.16, final payment. Final payment refers to the payment of the final progress, billing, and all approved claims, including but not limited to variation in the work, contract, price adjustments, and or escalation, acceleration of work, and others. It does not include the retention money. 1.17, guarantee bond. Guarantee bond is the approved form of security furnished by the contractor and his surety as a guarantee of the quality of the materials provided, the equipment installed, and the workmanship performed by the contractor. 1.18, instruction to bidders, refers to the list of instruction regarding the manners bids are to be prepared and the condition for the award of the contracts. 1.19, laws. So laws refer to all laws, ordinance, and other government. And 1.20, owner. Owner is the person or entity or authorized representative thereof who signed the contract as owner. 1.21, owner's representative. So it refers to the person or entity commissioned by the owner or authorized in writing the owner to act as his behalf. And 1.22, payment bond. So payment bond is the approved form of security furnished by the contractor and his surety as a guarantee of good faith on the part of the contractor to faithfully comply with the contract in respect of its obligation arising therefrom to its worker, subcontractors, and supplier. 1.23, performance bond is the approved form of security furnished by the contractor and his surety as guarantee of good faith or on the part of the contractor to execute the work in accordance with the contract. 1.24, schedule of materials and finishes. So it is an outline specification enumerating the type or trade names of materials required to be used by the contractor for the work. 1.25, specifications. Specification are the written or printed description of the work to be done, describing qualities of the materials to be used, the equipment to be installed, and the mode of construction. 1.26 Special provision or conditions. So it is the instruction which are issued prior to bidding to supplements and or modify the writings, specification, and or general condition and contract. 1.27 Subcontractor is a contractor duly registered and licensed by the Philippines Contractors Accreditation Board having a direct contract with the contractor and who act for or on behalf of the contractor in executing any part of the contract. One who merely furnish material without labor is a supplier and not a subcontractor. 1.28 Supplementary specification. So it refers to additional information which may be issued as an addition to or amendment of the provision of the specification. 1.29 Surety. Surety is the person, firm, or corporation which issue the bond required of the contractor. So 1.30 Limit or completion time. So it is the period allowed by the contract for the completion of the project or any stipulated portion thereof. And 1.31 Written notice means information, advice, or notification pertinent to the project delivered in person or sent by registered mail to an individual firm or corporation at the latter's last known business address. 1.32 Work. So the work refers to all contractor provided labor or materials or both, as well as equipment, transportation, or other facilities necessary to commence and complete the construction and to fulfill all his obligations which are called for in the contract. Article 2 Execution Correlation Meaning of terms Meaning of terms and intent of documents. So 2.01 Intent of contract. So the intent of the contract is to include all labors and materials, equipment, and transportation necessary for the proper execution of the work. 2.02 Standard of conduct. Each party to the contract acknowledge that in the exercise of the rights and in the performance of his duty, he must act with justice, give the other party his due, and observe honesty and good faith. 2.03 Interpretation of contract. In case of conflict between the provision of the agreement or of any contract documents or between the provision of one of the contract documents and the provision of another contract documents, or in case of discrepancy, defective description, error, or omission in the contract, the following rules shall be followed. So, rule number 1 the agreement and the contract documents shall be taken as mutuality explanatory of one another. The various provision of the contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all them taken jointly. Rule number 2 the provision of the Civil Code of the Philippines on the interpretation of contracts and of the rules of court on the interpretation of documents shall be applied. Rule number 3 where the conflict between or among the provision of the agreement and or the contract documents cannot be resolved by Rule 1 and 2. It shall be understood that the detailed drawing shall prevail over the general drawings. B. Words and figures shall prevail over the drawings. C. Words shall prevail and over figure in contract documents. D. Written dimension shall prevail over measured dimensions. Rule number 4. Where the conflict cannot be resolved by applying Rule 3 or where Rule 3 does not apply, the conflict shall be resolved by giving precedence to the agreement to the conflict or to the provision of the contract documents. Higher in order to priority among the various documents which comprise the contract. The order of priority among these documents shall be as follows. A. Agreement as modified by the notice of award of contract, if such be the case, and the contractor's conformity thereto. B. Instruction to bidders and any amendments thereto. And C. Addenda to bid documents. Agenda. D. Specifications. E. Drawings. F. Special conditions of contract. G. General condition of contract. H. Other contract documents. And I. Other documents forming part of the contract attached thereto or incorporated therein by reference. Where the order of precedence is modified in the agreement, such modified order of precedence shall be followed. However, the mere listing of contract documents in the agreement or any contract documents shall not be interpreted as establish an order of precedence among them. Rule number 5. Where there is discrepancy, defective description, error, or omission in any contract documents, the contract document shall be interpreted as being complementary to each other. Thus, what is called for in one contract documents, although not mentioned in another contract documents where it should have been mentioned, shall be deemed to be called by the contract. And Rule 6. The apparent silence of the drawing specification or any other contract documents as to any details or the lack of detailed description concerning any part of the work shall be understood to mean that good and accepted construction practiced in accordance with with the usage or custom of the place shall be followed. Rule 7. Rule 1 to 6 shall yield to specific rules of interpretation in this document or in the contract. B. The owner shall resolve the conflict or interpret or explain such discrepancy, defective description, error, or omission with due regard to Article 2.04 below. The interpretation of or explanation by the owner of the owner So the interpretation of or explanation by the owner shall be issued in the form of instruction to the contractor, where the owner fails to issue the instruction in writing. The execution of the part of the work affected by the interpretation or explanation without a timely objection or protest of the owner shall be deemed to have been executed in accordance with the owner explanation or interpretation. D. In all cases where a device, item, or part of equipment is referred to in the singular number, it is intended that such reference shall apply to as many such devices, items, or parts as are required the work to complete the work. 2.04 Conformity to the contract. The work shall be executed in accordance with the contract. If there be a variance between the drawings and the specifications, the provision of the specification shall control. In case of conflict between the general condition or any modification thereof and the detailed specification requirements, the detailed specification requirements shall control. B. Any discrepancy found between the drawing and the specification and site condition or any error or omission in the drawing, or specification shall be immediately reported to the owner, who shall promptly correct such discrepancy or error or omission any work involving such discrepancy shall be estimated by the contractor, and unit prices or lump sum amount shall be agreed upon by the parties whenever possible before the work is done. Any work done by the contractor involving discrepancy found by the contractor and not reported to and without the knowledge of the owner shall be considered as having been done at the contractor risk. C. The owner shall be fully responsible for adequacy of the design, for sufficiency of the drawings and specifications. The complete requirements of the work shall be set forth in drawings and specification to be supplied by the owner. In the event that any part or whole of the works when agreed upon are designed by the contractor, then all responsibilities assigned to the owner for the said design shall automatically be assigned to the contractor as his responsibility. 2.05 Meaning of terms. Approved, directed, and acceptable. The word approved, directed, and acceptable, or words of like import, shall mean approved, directed by, or acceptable to the owner. B. Furnish. The word furnish shall be understood to mean purchased and or fabricated and delivered to the job site or other location when so designated. And C. Install. Install. The word install shall mean to build in, mount in positions, connect or apply any object specified ready for the intended use. D. Provide. The word provide shall be understood to mean furnish and install. And E. Required. Required or necessary. The words required or necessary shall means as required or necessary for the complete execution of the portion of the work. 2.06 Timely exercise of administrative responsibilities. Whenever under the contract, the owner is required to exercise his discretion by A. Giving his decision, opinion on or consents, or expressing his satisfaction and approval, or determining value, or providing drawing, or supplying equipment or material, or otherwise taking action which may affect the contractor's timely completion of the work. He shall exercise such discretion fairly and in timely manner, taking due to regard of completion, time, and the approved construction schedule, notwithstanding any provision in the contract requiring the contractor to notify the owner when such action is due or when such equipment or material are due. Whenever in the contract, the contractor is required to give notice, submit data, catalog, samples, order, or import materials or equipment, prepare and submit the construction schedule, or notify the owner that a change has been ordered or an event causing a change has occurred or been discovered, the contractor shall do so in a timely manner so as to avoid any delay in the completion of the work. 2.07 Defective equipments, materials, work, or work. Whenever the contract of general condition provide that the owner may require the contractor to remove or replace defective or inferior materials or equipments, or to replace bad or defective work, the owner, if he is represented by the professional duly authorized to supervise the contractor's work and to exercise the discretion and authority of the owner, shall condemn such materials, equipments, or work in order to minimize the damage or loss of the contractor. However, where even with the exercise of due diligence, the owner could not have discovered the use of inferior materials and equipment or the defective work, the owner may condemn it upon discovery, and contractor shall bear all the costs for moving and replacing the defective or inferior material or equipment or the defective work. 2.06 Review of contract. The contractor shall carefully study and compare the various documents that comprise the contract and shall report to the owner any error, inconsistency, or omission that may be discovered in its provisions. The contractor, however, shall not be liable to the owner for any damage resulting from any such error, inconsistency, or omission in the contract. The contractor shall follow the drawings and specification and all additional detailed drawing and instruction issued by the owner as 9, being in full and strict conformity with the contract and the requirements of the work, except for shop drawing, product data, and samples for any portion of the work provided or supplied by specialty contractor and owners approved. Shop drawings, product data, and sample comply with the contract. The contractor shall not be liable to the owner for the undetected error, inconsistently or omission in the contract or for complying with instruction or following drawings or specification or for using or following the approved shop drawings, product data, or sample. 2.09 Document samples at the site. The contractor shall maintain in good order at the project site on a current basis one record copy of all drawing specification, addenda, change order, and other modifications and change made during construction, including approved shop drawings, product data, and samples. These documents and samples shall be available to the owner for the later's inspection. The contractor shall advise the owner on a current basis in writing of changes in the work made during construction except those made in accordance with change orders or owner's instruction. 2.10 Ownership of contract and models. The drawings, specifications, and models, including all additional instruction and copies thereof furnished to the contractor, shall remain the property of the owner. They are not be used by the contractor or any other work, and with the exception of the signed contract, inclusive of contract documents, they shall be returned to the owner upon completion of the work before final payment to the contractor is made. Article number 3. Drawing and specifications. 3.01 Copies of drawings and specifications. The owner shall furnish the contractor free charge 3 sets of drawings and specification inclusive of the signed contract. All other copies of drawing and specification as required by the contractor will be furnished to him at cost of reproduction. 3.02 Coordination of drawing and specification. All drawings and models are to be read and understood together with the specifications to form a part thereof where figures are given they are to be followed in preference to measurements by scale. Anything shown anything shown on the drawing but not mentioned in the specification or vice versa, or anything not expressly set forth in either, but which is reasonable implied shall be furnished as is specifically shown and mentioned in both. 3.3 3.03 Clarification of meaning of drawings and specifications. Upon request of the contractor, the owner will explain the meaning of the drawings, including notes thereon, or of the specification, or any obscurity as the wording of the specification. The owner shall provide the contractor directions and explanation necessary and proper to make more definite and certain any requirement of the drawing, including notes thereon, or of the provision of the specifications. 3.04 Discrepancy in drawings. The contractor shall report to the owner any discrepancy in the figure in the drawings immediately upon its discovery. The owner shall make the necessary correction. The contractor shall not be entitled to an adjustment of his contract price and completion time should his work be ordered redone if such work was made without notifying the owner of the discovery of the discrepancy and before the owner makes the necessary correction. Article number 4. Detailed drawings and instructions. 4.01 Supplementary drawings and instructions. The owner shall furnish additional detailed drawings and instructions essential to their proper interpretation and proper execution of the work. All such additional drawings and instruction are to be considered of equal force as those which originally accompany the specifications. Article 5. Shop drawings. 5.01 Condition in the preparation of shop drawings. The contractor shall prepare at his own expense and submit 2 copies of shops or setting drawings, templates, pattern, and models, and the owner shall pass upon them, making desired corrections, if any. The contractor shall make the corrections in the shop drawings required by the owner and file with the later 3 corrected copies thereof. 5.02 Identification. Identification. Shop drawings which shall be numbered consecutively shall represent all working and erection dimensions, arrangements and sectional views, necessary details including complete information for making connection with other work, kinds of materials and finishes. Shop drawing shall be dated and contain the name of project, the description names of equipment, materials and classified item numbers, and the location at which material or equipment are to be installed in the work. 5.3 Letter of Transmittal. Submission of shop drawing shall be accompanied by a letter of transmittal in duplicate containing the name of the project, the contractor's name, numbers, drawing, titles, and other pertinent data. 5.04 Corrections and changes and variations. The contractor shall submit 3 sets of prints of shop's drawings to the owner for approval. Satisfactory shop drawing will be so identified by the owner, dated, and one copy thereof returned to the contractor should shop drawing be disapproved by the owner. One set of such shop drawing will be returned to the contractor indicating therein the correction and change to the made. The contractor shall make the required correction and changes and resubmit the shop drawing in duplicate until the owner's approval is obtained. Upon the receipt of such approval, the contractor shall insert the date of approval on tracing and promptly furnish the owner with 3 additional prints of approved drawings. No work called for the shop drawing shall be executed by the contractor until the owner's approval given. If the shop drawings show variation from the contract requirements because of the standard shop practice or other reasons, the contractor shall make specific mention of such variations in his letter of submittal. 5.05 Responsibility for accuracy. If the contractor is a specialty contractor or is engaged by owner as a specialty contractor, the owner's approval of shop drawing will be general. It shall not relieve the contractor of responsibility for accuracy of such shop drawing, nor for proper fitting and construction of work, nor for furnishing of materials or work required by the contract and not indicated on the shop drawings. The owner approval of such drawing or schedule shall not relieve the specialty contractor from responsibility for deviation from the drawings or specifications unless he has in writing called the owner's attention to such deviation at the time of submission and secured the owner's written approval. 5.06 Owner's approval. Unless specified to the contrary or unless the contractor's submission is deficient, shop drawing approval by the owner shall be made within 7 working days of submission by the contractor. Section 2. Laws, regulation, site conditions, permit, and taxes. So we are now in section 2. So Article 6, Laws, Sites, Conditions. 6.01 Laws and Regulations. In general, the contractor shall comply with laws in so far as they are binding upon or affect the parties thereto, or the work. He shall also comply with regulation of firms furnishing utilities such as water, gas, telephone, and electricity for the project. If the contractor perform any work contrary to such laws or utilities regulations, he shall bear all. Site conditions. Before the bidding and the awarding of the contract, the contractor is expected to have visited the project site and made his own estimate of the facilities required in difficult attending the execution of the work. On account of local condition and all other contingency, The owner shall, however, furnish the contractor a geodetic survey and subsurface exploration which the contractor may rely upon in the preparation of his bid, additional costs arising therefore. Article 7. Permits, taxes, and surveys. 7.01 Permits and license. The owner, with the contractor's assistance, shall secure and pay all construction permits and license necessary for the execution of the work or of any temporary work and easement in relation thereto. The contractor shall secure the final occupancy permit, but he shall not be responsible to the owner if owner without his fault the license is not issued or there was delay in its issuance. 7.02 Taxes. Wherever the law of the place where the project is located required sales, consumers, use, or other similar tax related or pertinent only to the construction of the project, the contractors shall pay such tax. 0.03 Construction stakes and reference mark. The owner shall furnish all surveys describing the physical characteristics, legal limitation, and utility location of the site. He shall also furnish right of way for access of the site. The owner shall be responsible for the establishment of, lot lines, boundary lines, easements, and benchmarks, which shall be made by a certified surveyor. The owner may request the contractor to verify before the start of the construction the result of such survey, provided the owner shall pay for the cost of such verification. The owner shall also pay for any damage or cost to the constructor brought about by errors in data furnished. All other grade lines, level, and benchmarks necessary for the prosecution of the work shall be established and maintained by the contractor. The contractor shall provide and maintain well-built batten boards at all corners. He shall establish benchmark in not less than two widely separated places. As work progresses, the contractor shall establish benchmark at each floor giving exact level of various floors and shall lay out exact location of all partitions as a guide to all trades. 7.04 Service of Geodetic Engineer. 0.07.04 Service of Geodetic Engineer. The contractor shall, at his option or when so required under the contract, engage the service of a licensed geodetic engineer to confirm and certify the location of columns, centers, piers, walls, pits, trenches, pipework, utility lines, and work of a similar nature. The geodetic engineer shall also verify and certify the lines and levels of any part of the work at any time if so required by the owner. The certification shall be provided by the owner and the contractor if the geodetic engineer finds any deviation from the drawing in the work of the contractor. He shall report his findings to the owner within 24 hours of discovery. The contractor shall be responsible for loss or damage caused by the act or omission of the geodetic engineer, however, without accepting the contractor from liabilities, but in mitigation of it. The geodetic engineer certification shall be regarded as an independent and disinterested verification of such layout. Section 3. Equipments and materials. Article 8. General. All materials and equipment must conform to all laws, now or which may be in force and applicable during the period of construction. The contractor shall bear all damages by the reason of any delay in the work arising from his failure to comply with this provision. Where any revision or amendments to such laws is made during the construction period which affects the cost or time of completion of the contract or constructive change in the work shall be recognized and a corresponding contract price and completion time adjustment shall be made. Article 9. Equipment. 9.01 Quality of equipment. In order to establish standard of quality, the owner in the detailed specifications may have required to certain equipment by name and catalog number. This procedure is not to be construed as eliminating from competition other products of equal or better quality by other manufacturer were they fully suitable in design. 9.02 Equipments Substitution. The contractor shall furnish the complete list of proposed substitutions, preferably prior to the signing of the contract, together with such engineering and catalog data as the owner may requires. All requests for substitution of equipment shall be in writing. The owner will approve or disapprove the request in writing. No substitution equipment shall be used unless approved in writing by the owner. The contractor shall abide by the owner judgment as to which proposed substitute items of equipments are judged to be acceptable. Article 10. Materials, fixture, appliances, and fitting furnished by the contractor. 10.01 Samples of materials. The contractor shall furnish for approval sample as specified or required. The work shall be in accordance with approved samples. Unless otherwise specified, 3 samples shall be submitted of adequate size to show quality, type, color, range, finish, and texture of material. Each sample shall be labeled, bearing the material's name and quality, the contractor's name, date, project name, and other pertinent data. Where the specification require the manufacturer printed installation directions, such directions shall accompany the sample submitted for approval. A letter of transmittal in triplicate from the contractor requesting approval shall accompany all sets of samples. Materials requiring prior approval of the owner shall not be ordered until such approval in writing by the given by the owner. All materials shall be furnished substantially equal in every respect as their approved samples. 10.02 Trade name materials and substitutes. Whenever an item or class of materials is specified exclusively by trade name, by manufacturer's name, or by catalog reference, only such items shall be used except as provided in paragraph hereof. No substitution shall be made of any material, article, or process required under the contract unless the substitution is approved in writing by the owner. The contractor shall be responsible for materials and articles installed or used without such approval. Samples of materials for use in reinforcement concrete works such as steel bars, cements, aggregate, and the certificate of origin shall be approved by the owner. 10.03 Testing samples of materials. The contractor shall submit to the owner as many samples as may be needed for purposes of testing. Testing of all samples comply with the specification and government standards shall be performed by competent entity or testing laboratories approved by the owner. All cost of shipments, delivery, handling, and testing of contractor supplied sample are to be paid by the contractor. 10.04 Quality of materials. Unless otherwise specified, all materials shall be new and their quality shall be the best grade of their respective kinds, taking into account the nature of the project and requirements of the contract. 10.05 Storage and stockpiling of materials. The owner shall provide the contractor at or near the project site sufficient space for the contractors and subcontractor use for storage of their materials and for erection of their sheds and tool houses. All cement, lime, and other materials affected by moisture shall be stored on platform and protected from weather. The material shall be stored as to ensure their preservation of their quality and fitness for the work. For the work, stored material shall be located to facilitate prompt inspection. C. Should it be necessary at any time to move materials, sheds, or storage platform, the contractor so at this own shall do so at this own expense. 10.06 Defective materials. All materials not conforming to the specification shall be considered defective. The contractor shall remove or replace defective materials when ordered to do so by the owner. Upon the contractor's failure to do so, the owner may remove and replace them and deduct the cost of removal and replacement from any money due or to become due to contractor. No materials and defects of which have subsequently corrected shall be used until owner's approval is given. Should the specifications, drawings, special provisions, and supplementary specifications fail to provide any detail or description concerning the nature and quality of quality of the work to be performed, it should be understood that generally accepted construction practice shall be followed. 10.07 Important materials, fixture, and equipments. The contractor, taking into consideration the completion time, shall make timely arrangement for the purchase and delivery of all specified important materials, fixture, appliances, and equipment in order to avoid delay in the completion of the work. No extension of time shall be allowed if due to negligence or inadvertence of the contractor. Such imported items arrive late. 10.08 Owner's approval. Unless specified to the contrary or unless the contractor's submission is deficient, equipment, samples or material submissions shall be acted upon by the owner within 7 working days of submission by the contractor. Article 11. Materials, equipment, fixture, appliances, and fitting furnished by the owner. By the owner. Materials, equipments, fixtures, appliances, and fittings specifically indicated in the contract shall be provided in accordance with the owner approved construction schedule. Materials furnished by the owner shall be deemed acceptable for the purpose intended. The contractor may continue to use them until otherwise directed in writing by the owner. No further test shall be required unless the owner direct otherwise and pays the cost of such test. If the contractor discovered any defect in material furnished by the owner, he shall advise the owner in writing. The contractor shall be 17 responsible for material loss or damage to any owner provided material, equipment, fixture, appliance, or fitting in his custody. So if the contractor see a defect in the material, he should write a letter and advise it to the owner. Article 17. Royalties and patents. The contractor shall pay all royalties and license fee on all patented materials and processes furnished by him. He shall defend all suits or claims corresponding thereto for infringement of any patent rights and shall save the owner harmless from loss on account thereof. Article 13. Manufacturer's directions. All manufactured articles, material, equipment, appliances, fixtures, and fittings supplied by the contractor shall be applied, installed, connected, erected, used, cleaned, and conditioned by him in accordance with manufacturer's printed directions where reference is made to the manufacturer direction. The contractor shall submit the specified numbers of copies of such direction to the owner. So finally, we are done in section 1, 2, and 3. I hope you learn about the sections and its article. It's important for engineering, for future engineering. Thank you, and God bless.